What happens if you pass without a will or a trust? Hello, my name is Shanna Carter, and I help people prepare for tomorrow before tomorrow gets here by preparing their estate planning documents such as a will, a trust, a power of attorney, or an advance directive for healthcare. If you would like to discuss preparing an estate planning document for you or a family member, then you can go to my website at www.thesclaw.com and schedule an appointment. So what happens if you pass without a will or a trust? Well, if you pass without a will or a trust in the state of Georgia already has a plan for you. Unfortunately, you may not like that plan. In Georgia, we follow the rules of intestate succession when someone passes without a will or a trust. This is the order of priority in which your heirs or your family members will inherit your property. If you pass with children but no spouse, then your children will inherit everything. If you pass with a spouse and no descendants, then your spouse will inherit everything. If you pass with a spouse and descendants, then your spouse and your children will equally share in the intestate property. But the spouse's share may not be less than 1/3 of the total intestate property value. Intestate property is any property, both personal and real, that is not exempt from probate. If you pass with parents, but no spouse or descendants, then your parents will inherit everything. If you pass with siblings, but no spouse, no descendants, no parents, then your siblings will inherit everything. So let me give you a hypothetical situation. I want you to meet Martin and Elizabeth. They are both Georgia residents and they're married. So they have 3 children who are now adults. Martin and Elizabeth own a house in joint tenancy with rights of survivorship. Elizabeth is also named the beneficiary of Martin's retirement account. Martin dies unexpectedly in a car accident. He never took the time to make a will or any type of estate plan. Elizabeth would automatically inherit their home and any remaining retirement funds, as those 2 things are not subject to probate because they owned the house together as joint tenants and she was listed as the beneficiary on his retirement account. Well, Martin also owned $300,000 in other property assets. He did not share ownership in that property with anyone else, and he never made any type of arrangements in regards to what should happen to that property at his passing. Well, under the rules of intestacy, Elizabeth will inherit 1/3 of that property, which is equal to $100,000, and the rest of that property, the remaining $200,000, would be split amongst the 3 adult children. According to Elizabeth, her and Martin had already discussed what would happen to that property, and he was planning to have it all passed down to her if she survived him. Well, he unfortunately did not make a will. He never got any of this in writing. The state of Georgia has no way of confirming any discussions between Elizabeth and Martin, so they have to follow the rules of intestacy. So that is what happens if you pass without a will or a trust. Again, my name is Shanna Carter. I help people prepare for tomorrow by preparing their estate planning documents for them. If you would like to, you can book an appointment by going to my website at www.thesclaw.com. You can like and follow this video, and you can comment if you would like for me to discuss any other topics. You can follow me on Instagram. My name is Attorney Shanna Carter on there. I'm on TikTok. My name is Attorney Shanna. And here on YouTube, you can also follow me by following at Attorney Shanna on my YouTube page as well.